Teach the class video for LLB 344 Intellectual Property Law. Contributory infringement of a patent by the supply of products. A patent holder may take legal action to prevent the infringement of the exclusive rights granted to a patent. Patent infringement may be either direct or contributory in nature. The infringement is direct if a person, without authorization, exercises any of the exclusive rights conferred on the patent holder. Infringement is contributory, however, if a person who is not the patent holder or a licensee supplies a product where the use of such would constitute an infringement on the patent. The scenario: Company B supplies Company C with a particular product, knowing too well that Company C will go on to use the product in a way that infringes a patent held by the patent owner, Company A. As seen in the case Dunlop Pneumatic Tyre Company Limited and David Mosley and Sons Limited in 1904, Company B has not infringed the patent, however Company C will have. Company A, however, would rather impose penalties against Company B for the supply of a patented product. So how does this occur? Section 117 of the Patents Act 1990, Commonwealth, was enacted to provide better protection for patent holders. Under Australian law, a person may be liable for contributory infringement if that person supplies a product to another, in circumstances where the use of said product would infringe a third party's patent rights. The supplier of a product will be liable if A. The product is capable of only one reasonable use, being the infringing use, or B. The product is not a staple commercial product and the supplier had reason to believe that the recipient would put the product to an infringing use, or C. The product is supplied together with the instructions to use the product in an infringing manner. The contributory infringement provision set out in Section 117 of the Act seeks to balance the competing interests of protecting a patentee against the infringement of the patent while allowing suppliers to freely trade their products in the marketplace. After Section 117 was introduced, there was a highly restrictive view of what the provision was to give effect to, as seen in the case of Rest Care Limited and Anaesthetic Supplies Pty Limited. Justice Gumow's judgment advanced on the basis that the patent must be directly infringed by Company B, the supplier. But on application of Section 117 Part 2, A, B and C, this is shown not to be the case, and therefore there is no need to prove direct infringement by anyone, especially not Company B, the supplier. The case of Northern Territory and Collins, reported in the Commonwealth Law Reports in 2008, provides further discussion on Section 117 by the High Court of Australia. Mr. and Mrs. Collins were patent holders for a method of producing essential oils from cypress pines. The government granted licenses to the Australian Cypress Oil Company to cut down and take timber from the cypress pines located on Crown land. The Collins alleged that Section 117 applied so that the granting of the licenses infringed their patent by the Northern Territory, supplying a product, which would be caught under Section 117(2) Part B when used. There were three questions that the High Court considered in this case. Number one being, is the supply of an input for a patented process covered under Section 117(1) of the Act? On the appeal by the Northern Territory, the High Court answered yes to this question, allowing the patented method to be covered. Question number two raised the issue of whether the granting of statutory licenses could be seen as supplying a product under the Act. The High Court agreed with this, as the word supply has a broad meaning. Question 3 investigated whether the timber in question could be seen as a staple commercial product under the Act, and the High Court found in favour of the Northern Territory that the timber was a staple commercial product. The necessary questions that need to be asked when contemplating whether an infringement has occurred under Section 117 of the Act are: 1. Is there a supply of the product? 2. What is the use of the product in relation to Section 117(2) of the Act? 3. Does the use identified infringe the patent at all? These combined will help to determine the infringement of a patent under Section 117 of the Patents Act 1990, Commonwealth, by the supply of products.